Well, good morning, everybody, and thank you for joining us at our webinar this morning, all about wills and probate during lockdown. I'm delighted to be able to introduce you to Helen Jago, who's a solicitor and a member of STEP. Helen's going to take us through her content, first of all, relating to wills and probate during lockdown. We will have lots of time for questions during this webinar, so for those of you that are used to using Zoom, you'll be familiar with the Q&A, which sits on your toolbar in Zoom. Please use that panel during the presentation to put forward any questions you would like Helen to answer. And we're going to save some time at the end of the presentation today to take those questions. Hopefully we'll get through all of them. Those that we don't get through, if we run out of time, we will come back to you on a one-to-one basis and try and answer all of those individually. You can also use the chat panel, which allows you to converse with us directly. But again, with the questions, it would be a lot easier for us, if you don't mind, if you use the Q&A panel. So at this point, I'm going to hand over to Helen, and I will see you at the end of the session. Over to you, Helen.
Thanks, Jo. Thank you for that introduction. So if I can have the first slide up, Jo. Thanks, Jo. So I'm just going to go straight into what I'm going to be covering in today's webinar. So the questions I'm going to be looking at today are: can I still make a will during lockdown? What happens if I don't have a will? What are the current inheritance tax thresholds? Can I still apply for probate during lockdown if a loved one passes away? And finally, which I'll be kind of interrelating throughout all those questions, is how can Palmers help us complete a will or assist us with probate if I am shielding still, which is still the case for lots of people. Have the next slide, Jo, thanks. So the rules for making a will have not changed or been relaxed during lockdown at all. The government thought about it, but they decided to leave them as they are to make sure they're still safe for people. So the key points to note when making a valid will are: a will must be signed by the person making the will or at their direction if they cannot sign, in the presence of 2 independent witnesses. Note the word independent there. The witnesses cannot be named in the will or married to anyone named in the will. If they do, if the witness is named in the will, it will have disastrous consequences because the witness will actually be written out of the will. Just to give you an example, I went to see a fairly wealthy lady to review her will, and she just said, can you just check it's all in order? And I had a look and I noticed that the daughter was also the witness. And so I checked that with her, and she said, oh yeah, my daughter was one of the witnesses. And I basically explained this would have the effect of writing her daughter out the will, and she was one of the main beneficiaries. And this would have been the same if her son-in-law had witnessed the will as well. So of course she obviously had to do a new will. Now the next slide, Jo. The independent witnesses must be physically present when you sign your will. So unfortunately, what we thought might be okay was watching someone on video call. That would have been useful during this current lockdown, on Skype, WhatsApp, Zoom, etc. We could have watched them and said, yeah, we've seen them, but that's not enough. You actually have to see someone sign and be in their physical presence. If you get the signing formalities of a will wrong, this means the will is invalid and your wishes will not be followed. So, for example, my colleague once dealt with the estate of a lady. She wanted to leave her estate equally between 2 charities. It was all nice and quite straightforward in itself. The will was done and written perfectly fine in itself. She signed it in the presence of 1 witness. But as there were not 2 witnesses, sadly that will for that lady was invalid. And instead of each charity would have received approximately £100,000 each. Unfortunately, what happened was her entire estate got distributed under the intestacy rules between various cousins, second cousins, etc., some of whom lived in Australia. And I think there was a family tree my colleague had going round, you know, a really good sized living room with all the different beneficiaries. So it's imperative the will signing formalities are correct. Have the next slide, Jo. So how have Palmers overcome this hurdle during lockdown safely? So we've taken the following steps. Firstly, we've taken instructions and viewed identification by way of a video call in the first instance. I'm not sure where the little logos have gone there, but there was some little, there we go. So first of all, we've taken instructions, and that's all been quite safely done remotely. I've then emailed out the drafts to the clients with an accompanying letter of advice, as I normally would, so they can review them in the comfort of their own home. And then I will talk through with that will with them over the phone, just absolutely check we're on the same page before preparing a nice top copy all sewn up, ready for signing. Next slide, Jo. So when it comes to witnessing the wills, we've either sent the top copy wills to our clients for home signing in front of independent neighbours, and we send a clear instruction sheet on home signing explaining who can and can't be witnesses. And then we actually ask for that will back just to check it all appears to be in order once it's signed, make sure they have actually got round to signing it. Another more innovative way that we've helped our clients complete their wills is we've actually attended on clients in their front gardens, and we have of course been blessed with this really lovely weather at the moment, so this has been possible and actually quite good fun. So I've had people set up little tables out the front. We have, I think it was in the news one time, people were signing on car bonnets, and we do this really safely. So what we've been doing is I've been taking the will, putting it down on the floor, the table, a little stool, etc., stepping back 2 meters. The testator comes in, signs with their own pen, steps back. The witness, maybe next door neighbour standing in their own garden, then steps forward, witnesses the will, steps right back. I step forward as the second witness the will, and then take that back with me. Everyone uses their own pens. I remind everyone to wash their hands afterwards. The only thing we've all touched will be the will itself. So really quite safe, all in the open. So we've been able to help people that way. We also then prepare an attendance note when I get back to the office, which is like a record of the logistics of that will signing, just in case there is any later query or someone says you couldn't have possibly done a will in lockdown. How did you do it? Well, we've got a record saying, well, yes, we did, and we did it safely, and we complied with all the rules. Next slide. So maybe you're thinking, well, I won't bother. What happens anyway if I don't have a will? So first of all, if you're thinking, well, I need to update my will, but I won't bother, I'll just leave it. If you've got a will that you made years and years ago, even if it was like 30 years ago when you were with a partner you're no longer with, or when your children were babies and you appointed a friend you no longer see as their executors or guardians, that will is still valid. It doesn't matter that your circumstances have changed. It doesn't revoke itself. So any earlier will you've made, you have to be careful, because that will always be relevant until you make a new will or you destroy that old one. If you've never made a will at all, what happens is the intestacy rules come into play, and that's what I'm going to look at next. Next slide. As you can see from the chart, the rules essentially depend on whether you're married or in a civil partnership or not. So when I refer to marriage throughout, it applies equally to civil partnerships, registered civil partnerships. And I'm going to be looking at the rules in England and Wales. And this is what happens. So hopefully you can all see that flow chart. It's quite nice and big on my screen. So if you're married and you've got children, what happens is this: your spouse will receive the first £270,000 now. It's worth noting that this has increased from £250,000 on the 6th of February just this year. It was rather quietly, without much media attention, and I think even when I looked, HMRC didn't even update their flow chart with this amount for a couple of weeks. But that's what it is. The first 270 goes to the spouse. All personal chattels also go to the spouse, and personal chattels is things like your cars, your vehicles, your household goods, your personal possessions, your jewellery, everything like that. That all goes to the spouse. And half of everything else over and above what I've just said also goes to the spouse. The remaining half of everything else will pass to your children equally on the statutory trusts. And that means that if any of your children pass away before you, their share will go to their children. So if you've got 2 children, one sadly passes away, leaving 3 children of their own, half goes to your surviving child, the other half is split between 3 grandchildren. If you're married without children, then your spouse receives everything now. There's no longer any provision if you are married for your parents, siblings, etc. to get anything from your estate. If you're not married or in a registered civil partnership, your partner, even if you've been together 30 odd years, whatever, will receive absolutely nothing from your estate under the intestacy rules. So for unmarried couples, it is absolutely essential, even more so than married couples, to make a will. It is also, however, worth noting that any joint assets will normally automatically pass to the surviving owner. So a joint bank account will normally pass to the surviving co-owner outside of the intestacy rules, as will property, so houses, flats, etc., owned as joint tenants pass to the surviving owner. However, it's important to note that property owned as tenants in common will not pass automatically to the surviving co-owner. That share of the property of a tenant in common, when it's held as tenants in common, will pass under the first person's will or their intestacy rules. So when we're preparing wills for clients, we always look at how the property is owned. Is it tenants in common? Is it joint tenants? Do we need to make any changes to make sure their will has the desired effect? If you're not married, but you've got children, that's quite simple actually. Your estate is divided equally between your children on the statutory trust I've mentioned before, so on to grandchildren, great-grandchildren, etc. If you're not married and you have no children, no grandchildren, then there's an order of inheritance between your relations, a strict order. So just to give you an example, I've dealt with 2 estates recently, and the list of beneficiaries included cousins. That's where it got as far as aunts and uncles of the whole blood of the deceased. They'd all died, their children, etc. And quite often one side might be well known, so they might know about the deceased grandma's side, but actually not know anything about the deceased granddad's side, and who his brothers were, say, for example, his sisters were. And so often the administration of an intestate estate will involve identifying and locating those beneficiaries to make sure we have all the heads of the family identified, and all the lines of distribution. Can I have the next slide? So it's worth just noting that often seemingly the most simple set of instructions can end up complicated, and with the need to identify and locate heirs, often across the globe. I've personally had several cases involving beneficiaries in Australia. I've had a couple literally this year. I've had a case once where the search company had to involve a parish priest in Ireland to try and locate and identify and get a birth certificate for a potential beneficiary under intestacy. And so we were reliant on this parish priest checking the records, because that was the only records at that time in Ireland of someone's birth. So you know, it can be really tricky, and so a will is so much simpler. Best practice, make a will, avoid the intestacy rules, even if you think your circumstances are very simple. Next slide. So now we're going to get a little bit more technical, and we're going to look at inheritance tax. So it's worth noting that all assets transferring to a surviving spouse, but not an unmarried partner, so again this is only spouses and registered civil partners, are inheritance tax free. You can have £1 million, £1 billion, it won't matter. If it's going to your surviving spouse, it's inheritance tax free. That assumes they're domiciled in the UK. Slightly different rules if it's being left to a spouse who's outside of the UK. The current nil rate band, this is the maximum amount that can be left to sort of any other beneficiary other than your spouse, without tax being payable, is £325,000. So that's what an individual single person has, £325,000. The transferable nil rate band, this is something relatively new. Some people still not sure about this. What it means is, on the death of the survivor of a married couple, the survivor's executors under current legislation can claim any unused portion of the nil rate band of the first spouse to die, as well as the survivor's own nil rate band. So, for example, if a husband dies and he leaves all his estate to his widow, he doesn't use up any of his nil rate band because his gift was spouse exempt. When the widow later passes away, her estate benefits from her own nil rate band of £325,000 plus her late husband's nil rate band of another £325,000. So in very simple terms, it's a little bit more detailed than this, but in simple terms, a married couple have up to £650,000 between them in most circumstances. Next slide. So the residence nil rate band, this is relatively new. This only came in on the 6th of April 2017. The current residence nil rate band is £175,000, but it only applies in certain circumstances. And so this is another tax-free amount like that original £325,000. This is an additional amount of £175,000, and we're going to look at when that applies. So for this current rate, it's if the person dies after 6th of April 2020. Before this, it was lesser amounts, starting at £100,000 back in 2017. It only applies if they've got a residence which is being left to lineal descendants, so children, grandchildren, etc. There are provisions to allow for the relief to apply if you've downsized or even sold your property by the time you pass away. The rules are quite complex, and if you're thinking of downsizing or selling altogether, it's probably worth seeking specific advice on this point if you are worried also about inheritance tax. The residence nil rate band is only available if the property passes to direct descendants, and that can be either as a specific gift. So, for example, I've got 2 children. If I leave in my will a gift of my property to my children, Henry and Lily, in equal shares, that's fine. The residence nil rate band will hopefully apply. If I leave my whole estate, my residue to Henry and Lily in equal shares, and that includes a residence, again, the residence nil rate band should apply. It won't apply if the residence is left to unmarried partners, parents, nieces, nephews. If you've not got any children, you're actually penalised here. You don't get this initial, this extra residence nil rate band. If there are a mixture of direct descendants and other beneficiaries, then the relief may be reduced because it only applies to your estate to the extent that is passing to your direct descendants. There is a risk that this allowance could be lost completely if there are certain intervening trusts. So even simple, more traditional trusts, like I want to leave it in fact to my grandchildren, dependent on them reaching an age of 25 when they're a bit more sensible. At that point, even stating an age for the grandchildren to inherit, if they've not attained that age when you pass away, the government say, well, no, you haven't left it to your grandchildren, you've left it into a trust, and therefore the residence nil rate band will be lost. Therefore, now when we're drafting people's wills, we do take into account the residence nil rate band and discuss this with people and make sure it's drafted appropriately, bearing this fairly new allowance in mind. It's also just worth noting that the residence nil rate band is tapered down for estates worth more than 2 million. So by the time, if you've got an estate worth, I think it's 2.35 million, you can't get any residence nil rate band at all. You're back to the 650,000 married couple allowance or 325,000 for a single person allowance. It's also worth noting, just like explained with the transferable nil rate band, the residence nil rate band is also transferable between spouses. So I know that was a lot to go through, but that's the new residence nil rate band in a nutshell. Have the next slide, Jo. So just to break that down a little bit, how do the nil rate bands all interact with each other? I'm just going to take a really straightforward example here. We've got a married couple, we've got a house with at least £350,000 of equity in it, passing to their children when they've both gone. They can have an estate worth up to £1 million before inheritance tax is payable. It's worth noting I've sort of highlighted the £350,000 of equity in the property, because if you've got a large property but it's heavily mortgaged and for some reason you've also got lots of cash outside of the property, note that it will only be the equity in that property up to the £350,000 which is able to get the benefit of that residence nil rate band. So how does this £1 million of tax allowance come about? Spouse 1 has the £325,000 nil rate band. Spouse 2 has their own £325,000 nil rate band. Spouse 1 has the residence nil rate band of £175,000, and spouse 2 has their own residence nil rate band of £175,000, and there you've got your £1 million total tax-free nil rate band available. Anything above the available nil rate bands, whether it is that £1 million for a married couple with children, or whether it's one or more of those combinations, anything above what's correctly available is taxable at 40%. So you don't want to be losing out on any nil rate band you're entitled to. And next slide, please. Other points to note generally regarding nil rate bands. There's no spouse exemption between unmarried couples, so anything passing to an unmarried partner will eat into that nil rate band. Also, double whammy, the residence nil rate band and the nil rate band are not transferable to an unmarried partner. So again, it's just wasted if it passes to an unmarried partner. If you leave your property to an unmarried partner who is not the parent of your children, it might be taxable in that first instance, but it might also be taxable when your partner passes away, if it ultimately passes to your children. And in that case, you've wasted that opportunity to use your residence nil rate band. So sometimes you just have to weigh up how to structure your will in light of this now sort of more complex will drafting situation. Need to carefully consider the circumstances in each case with unmarried partners when you've got children and you want to use this residence nil rate band. Next slide. So other points to note, this is just almost just to throw in there, there's lots of things to consider when tax planning. You can use different type of trusts, they all have different tax consequences. Lifetime gifts are relevant for tax planning, so any gifts in the 7 years before you pass away are taken into account. They eat into your nil rate bands. If you've got business assets, they can be sometimes eligible for business relief for tax purposes. Same with agricultural land. There's agricultural relief sometimes available. Charitable gifts are tax-free, like with a spouse, 100% inheritance tax-free. So a good way of tax planning, be philanthropic, and then you can leave it to charities. If you've, there's only so much we can do in your will. We can't change the rules, we can't extend the allowances in your wills. So sometimes if you've got an inheritance tax problem, what we recommend is you speak to a financial planner or financial advisor, and you seek, and sometimes they can recommend investments and products which will all be inheritance tax sufficient depending on your needs or requirements. All these sort of things are relevant, and we sort of consider these with you when you're making a will to the extent it's relevant to you. Next slide. So I've now covered wills and intestacy rules. I'm just going to now move on to what happens if the worst does happen and you do need to apply for probate for a loved one, even during lockdown. Palmers can still assist with this even at this time, and I have been, and we've been getting some grants back already. What we've been doing again to keep it safe during this time, we've been using video calls to take instructions. We've been following it up with email, which is quicker at the moment. And there's also a relatively new online probate platform for professionals, which is now the court's preferred method of application. It's still in its beta stage, so it's not perfect, but the grants are going through, they are coming back. So yeah, we basically explain all the relevant parts, and we have been able to make these applications even if they're a little bit slower at the moment. Next slide, please, Jo. So I'm just going to look at what are the sort of key points we need to consider when advising someone on a probate. We would look at utilities, also building insurance. Sometimes that's one people forget. Just absolutely make sure the buildings insurance company is notified, that they have noted any endorsements, they know it's empty if relevant. Assets and liabilities, we would say, have all the organisations been notified? We can assist with this. Sometimes people have already said there's just one bank, we've told them already. We need to, for every single asset, we need to get a valuation of that asset in order to apply for the grant of probate. And we've been able to successfully put clients in touch with valuers who have still been able to work, normally innovatively and safely during this difficult time, so we can get those values we need. We'd also need to work out if inheritance tax is payable and have all the relevant inheritance tax allowances being claimed. So as mentioned above, the rules can be quite tricky as to which nil rate bands apply, how to claim them and when to claim them. It is important that the transferable nil rate bands are claimed within the correct time period as well. So never sort of sit on a probate because you want to make sure you get all those allowances, because the tax can be thousands of pounds different, you know, if you don't claim the right ones. Is a full inheritance tax return required with detailed schedules where you have to list all the sort codes, all the account numbers, or can we get away with completing a simplified inheritance tax return, which is a 4-page essentially form? It depends on the value of the estate. It also depends on the nature of the asset. We can assist with preparing the legal statement for signing by the executors, which is necessary to get the probate application. Now, only back in November 18, it changed from oaths, where you went and took your oath and you swore that before another solicitor. It changed to statements of truths. Really recently, they say they don't even want statements of truths. Oaths have gone, statement of truths have gone. We now have this thing called a legal statement, which is signed by the executor, very, very similar, but it's made life a little bit easier during lockdown because you haven't got to traipse to another solicitor to get this sworn. And then we can either make online applications, or certain applications still need to be made in paper. So example, an intestate estate with more than one administrator, we still need to make a paper application for that. There's still paper, to be honest, even with the online applications, there's still forms to sign. Really much hasn't changed there. We can assist with the collection of the assets. So once we've got that grant of probate, we would look to collecting the assets, fill out these share forms, fill out the bank forms, and then once we've got those assets in, we would look to prepare the administration accounts, distribute to the relevant beneficiaries after carrying out appropriate bankruptcy searches to make sure none of the beneficiaries are bankrupt. And this helps the executors as well, because they haven't got to bother with opening up an executor's account, which can be tricky at the best of times, and certainly during these during lockdown. So we can collect the monies into the Palmers account, prepare the accounts, distribute out to the beneficiaries without the executors ever having to open up and manage that money themselves. If there's any ongoing trusts, again, we look at those and we just double check. Is there any trust in the will, such as young grandchildren, or maybe someone said, I would like to leave my house to my spouse for his life, but ultimately to my 2 children. So we would look at, well, in that case, what action, what initial steps need to be taken, what ongoing arrangements need to be made, do the deeds need updating, etc. Again, we would always talk that through with our clients. You can see at the bottom there that we always do aim, our whole team are really friendly and approachable, and we aim to handle all our probate cases sensitively and with a view to trying to make them as stress-free for the family involved as we possibly can, obviously at this difficult time. Next slide, please, Jo. So to conclude, yes, you still can make your will during lockdown. I've helped several clients make wills, so have all my colleagues. It's absolutely possible and it can be done safely. What happens if you don't make a will? Then you risk these intestacy rules applying. We've seen they can have random consequences, often involving costly searches for beneficiaries and identifying them and not getting what you want at all, even in the simplest of cases. We've seen that the current combined inheritance tax threshold for a married couple can be as much as £1 million, only in certain circumstances, and it's important that those available allowances aren't wasted by sort of sloppy will drafting. Yes, you can still apply for probate during lockdown. I applied at the start. I've got a couple back now, so that is working. And yes, Palmers can assist you with wills and probate, and of course lots of legal needs, professionally, sensitively, and at the moment, importantly, safely. Thank you for listening. I hope there's been something there you've either learned or at least been refreshed on. And I'm going to pass you back to Jo Edwards.
Brilliant. Thanks very much, Helen. Well, I said we'd have time for questions at the end, and we have got quite a few questions coming in. So I'm going to field these out to you, Helen, if that's okay.
Okay.
So we had a question pre-webinar coming from Vicky. So Vicky has personally got wills organised, but the MD of her company doesn't.
Okay.
So the question was about the implications of a sole director passing away and with no will, and what happens to the future running of the business on that basis.
Okay, so it might be a crossover there between probably our company team and our wills team. So often what will happen is it will depend on the company's articles of association, memorandum of association, and it will often empower the shareholders to appoint a new director in those circumstances. It is obviously really important that the director does make a will, not really leaving his directorship, but really leaving his shares to his beneficiaries, and maybe there needs some shareholder agreement about you know, and obviously when making a will we have to consider the interaction with the articles, and is it possible to leave those shares to who that person wants to leave them to? Is it, you know, is there any restrictions on how the shares pass? But the directorship question, it would normally be if there's a sole director dies, there's no other directors to continue on, it would normally be down to the shareholders.
Okay. Another question here from Kathleen, who's asking about how often should wills be updated. At the moment, I think they do theirs every 6 or 7 years. And a secondary question, they also live in Greece, and whether this transitional year will make any difference to their UK will.
Oh, well, okay, so how often should you review your will? There's no golden rule to this. I normally say maybe just get your will out, or your copy will, have a look at it maybe every 5 years, or earlier if there's a big change of circumstances. So if you marry, obviously, because that can revoke a will, if some key person dies, if you move abroad, if you have like lots of different assets, you inherit money. So reviewing a will would be change of circumstances, or perhaps at least every 5 years, I would say. You don't have to change them every 5 years. It might be you put them away and never need to change them, but just have a look at them and check. Okay. If you're in Greece, and the rules changing, I don't know. I don't think I probably know anymore. I think I would say that would be a significant change. So just make sure I get advice at that time once, you know, Brexit's happened, and just absolutely check the wills are still going to work for you how you want them to work.
Okay, thanks, Helen. I have a question here from Sheila. So Sheila's asking, the witnesses signing the will, can they be a married couple unrelated to me and not named in the will? And does my solicitor need to be present?
No, so a married couple that are not in the will, not related to you, not being left anything, not executors in the will, not guardians or anything like that, then that's absolutely fine. Doesn't matter that the witnesses are married, that's fine. In fact, me and my husband have sometimes witnessed people's wills, so that's fine. Yeah.
The solicitor being present?
No, the solicitor doesn't have to be present. All I just say is, you know, with homemade wills is I think the risk is that you do something a little bit wrong. But no, there's no magic in a solicitor being present, other than they'll do an attendance note to say it's all been done properly, sort of thing.
Okay, all right. There's a question here relating to inheritance tax from Tony. So the question is, the £350,000 of equity in a property for residence nil rate band, can you not actually claim the residence nil rate band at all in any part unless you have this much net equity available in the property after both parents have passed?
No, so what it is, it's you can still claim it, but it's capped. So 350,000 is the maximum now, because you've got the residence nil rate band for spouse one of 175,000. You've got of up to 175,000, and you've got the residence nil rate band of spouse two of up to 175,000. That's how we've got up to 350,000. If you've got £270,000 of equity in that property, the residence nil rate band on the estate will be capped at £270,000. It's not all or nothing. But if your estate, if you've got an equity in your property of £500,000, it doesn't matter, it's capped at 350,000.
Okay, right, we've got a thanks from Tony, so thank you for that. Question here from Peter. I'm getting a civil partnership in July. The mortgage is currently in my sole name, so should I add my partner's name onto the mortgage after we're married?
I would just mention that a civil partnership or marriage does revoke a will. So that's one thing to note, that you should definitely review that. As to whether you put your partner's name on the deeds, it's entirely up to you, and it might depend on the mortgage company's requirements whether they allow that. What I would say is you either put them on the deeds if you want it to automatically pass to your surviving co-owner as joint tenants. If you're happy to leave your property subject to the mortgage to your civil partner, whether you're married or not, do a will and make sure that's what you state in it.
Okay. And I have another question here from Vicky. Where a married person dies with no will, the surviving spouse receives assets with no IHT, but the part of the estate passing to the children, I assume that's subject to IHT at 40%.
Yeah, so the money passing to the spouse does not eat into that nil rate band at all. But the money passing to the children, if it's less than £325,000, there's no inheritance tax. If the residence is partly going to the children as well, there might be that additional residence nil rate band. Anything above those nil rate bands available will be taxable at 40%. That's correct.
Okay, perfect.
Because sometimes in that situation, sometimes the family will enter into a deed of variation for inheritance tax purposes.
Okay. And I've had one question come here to me in the chat room. So it's a question about, I am separated but still married. We made our will. Is that will still valid even though we're separated?
Yeah. I think there is a distinction actually between a separation agreement and a formal deed of separation that's been sealed by the court. So just be a little bit careful there, because that can change the rules a little bit. But generally, if it's when you're divorced, it's treated as if you've predeceased your ex-spouse. So I'd probably say it's best to review your will if you're separating for any length of time, really, and just make sure it still does what you want it to do.
Okay, brilliant. Okay, and we've got time for one last question. This is from David. If a property is sold at less than the probate valuation, can you reclaim some of the IHT paid?
Yeah, so if you've paid inheritance tax, so that the estate is taxable, there is a loss relief you can claim, and I think it's 3 years actually. I looked this up the other day. I can't remember. He said it might be 3 or 4 or even 4 years. But you basically can claim. You can claim loss relief. I've got one going through at the moment. Actually, I think there's a de minimis, maybe of £1,000 or something. You can't claim, but yeah, generally, if it sells for quite a lot less, you can claim that back.
Okay, lovely. Well, look, thanks very much, Helen. That's been incredibly useful. I hope the audience have enjoyed that and got some information to take away with them. We will make a copy of this webinar available as an on-demand version on the website. So that should be edited and up by tomorrow latest. So if you want to re-watch, you're more than welcome to. But thanks, Helen, and thank you to everybody that's joined us today.
Thank you. Thanks, Jo.